And of course, South Africans are now allowed to comfortably smoke pot at home without being policed. But does that comfort extend to the workplace? Well, Gavin Stansfield is the Director of Employment Law at Cliff Decker Hofmeyer Attorneys. He joins us via Skype to expand on this. Thank you very much for your time. Now, unless your job actually requires that you get tested from time to time, it's going to be very difficult for employers to determine whether someone is high at work. Gavin, how do they actually do this?
Well, evening, Dudu. Presumably there are tests available that you can do this, as there are testing mechanisms similar to testing for alcohol use within the workplace, simple ones such as breathalyzers. Of course, you're always going to have circumstantial evidence as well. You can observe people, get to know what the signs are of someone who's under the influence of an intoxicating substance such as marijuana. And in the absence of a test, as long as those circumstances are strong enough and clearly observable, then I think that's always going to serve as evidence. But of course, these things are difficult to judge, and no doubt employers are going to have to give some thought in terms of how they go about testing, either on some form of reasonable suspicion, and science is going to have to answer the question in terms of how they go about conducting these tests in the workplace, something that's readily accessible and something that you can do with the employee's consent, of course.
Right, let's expand on that. Is it about time that employers actually maybe just changed or reimagined their policies when it comes to this issue?
Yes, without question. One can use the analogy of again, alcohol use in the workplace. So alcohol is the consumption of alcohol, of course, is not a criminal offense. And the consumption of marijuana now for personal consumption in a private space is now no longer decriminalized. Of course, that doesn't mean to say that you can now go to work and consume it at work, even if you can argue that work is a private space. Employers are obviously going to have rules in place in terms of which they prohibit this. There are also safety concerns in terms of occupational health and safety that need to be observed. So, people mustn't think all of a sudden that it's now decriminalized, that this is a license to go to work under the influence of it. Employers must have rules which prohibit the consumption or being under the influence at work, and unquestionably they're going to have to review their policies in this regard.
On the point you made earlier of testing, how big an issue is consent when it comes to the workplace and people being tested? Of course, there are jobs where you can't go untested because of the nature of the work that you do.
Look, consent is required. Consent can normally be given up front in a contract of employment at the time of contracting, where the employer makes it a term and condition of your employment that it will, subject, of course, it helps if there is some sort of reasonable suspicion as opposed to random drug testing, which is a little bit trickier. But if at the time of contracting, the employer includes a clause in a contract which says that you will consent to this. And of course, if you fail to give your consent at the appropriate time, this can be regarded as some form of a breach of your contract of employment, perhaps a form of insubordination. Coupled with, as I've said, if the testing is on account of some form of reasonable suspicion where your manager and clearly anybody who observes you can observe that you appear to be under the influence of marijuana, as an example, there are certain telltale signs, coupled with your refusal to heed a contractual term in your contract, this will no doubt be reason for some form of disciplinary action.
What about the Labour Act? Will that be subject to change, or should it be subject to change, given your stance on saying that perhaps it's time that companies reimagined the whole issue of dagga use in the workplace?
I don't think the Labour Act needs to change. Inherent in the Labour Relations Act is the establishment of rules within a workplace, which sets standards of conduct. They must be reasonable, of course. They must be fair. So that the Act already provides for that, and in fact it's inherent in any workplace policy or practice that an employer will establish rules. The use, not so much the use, it's difficult to see under what circumstances employers are going to allow any form of use, but perhaps more interestingly, the possession of small amounts of marijuana on your person in the workplace. I think that's going to be a little bit more difficult to legislate and to regulate in terms of policy. But it's all going to come down to operating, I think, within the existing framework of the Labour Relations Act and establishing those rules. It's usually done through policy, communicating the policy, and of course enforcing any breaches of it.
So Gavin, essentially don't think you can come to work high and that will be let to pass.
I'm sure there are going to be people who are trying, who will try and take, test the employer's rules, but no, it's that part of it unquestionably is still going to be illegal.
100%. Thank you very much for your time. Employment law expert Gavin Stansfield discussing potential new company drug policies.